Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Sabha TV. Today we bring to you the Payment of Gratuity Amendment Bill 2017. To discuss the issue, I have with me Dr. Onkar Sharma, Deputy Chief Labour Commissioner, and Mr. Ravinder Gupta, Joint General Secretary, All India Bank Officers Confederation. Now for the highlights. The bill seeks to allow maternity leave as part of continuous service. It empowers government to fix new ceiling of gratuity without going to the parliament. Gratuity is payable to most employees who have completed 5 years continuously in an establishment. The Payment of Gratuity Amendment Bill 2017 seeks to allow the 26 weeks of maternity leave available to women employees as part of service period while calculating gratuity. The bill also seeks to allow government to hike gratuity from the existing limit of 10 lakh rupees. Gratuity is paid to all employees who have worked continuously for 5 years in establishment.
The Payment of Gratuity Act provides a scheme for the payment of gratuity to employees who have worked for 5 years continuously with an establishment employing 10 or more persons. The gratuity amount is calculated on a formula: 15 days of wage for each year of completed service, subject to a ceiling of 10 lakh rupees. A lot has changed since the law was made 45 years back. Now the government intends to upgrade the law.
Actually, government after a long time have brought a bill in the parliament for the changing in Gratuity Act. The basic changes which are very important from the point of view of the workers are that they are enhancing the amount. So almost they have doubled. Earlier it was 10 lakh, now it has become 20 lakh. So looking the conditions and the spiraling price rise, I must say that they have kept with the dignity of the labor and they have brought this change. That is a welcome step of this government.
The Payment of Gratuity Amendment Bill 2017 allows the central government to notify the revised maternity leave of 26 weeks for female employees as part of continuous service. The government had recently enhanced the maternity benefits to 26 weeks from the existing 12 weeks. The bill proposes to empower the government to notify the ceiling proposed so that it doesn't need to come to Parliament to amend the law. It can also revise the limit from time to time, keeping in view the increase in wage and inflation and future pay commissions. As of now, the maximum gratuity amount is 10 lakh rupees, which needs to be enhanced.
Earlier, the maternity benefit period of the women employees are considered as their period of service. It is nothing new. But it was 12 weeks as per earlier old law. In between, there was an amendment of the maternity benefit law, which was made 12 weeks to 26 weeks. Now, that enhanced period will also be treated as their continuous service. And in this bill, another point that has been brought, that is a welcome thing, that henceforth for changing the ceiling or changing the maternity benefit period, if it is changed, they need not bring the bill to include it in the gratuity calculation. They need not bill again a fresh bill. By this amendment bill, the government is empowered, the executive is empowered to declare changes in the ceiling amount.
After the implementation of the 7th Central Pay Commission, the ceiling of gratuity for central government employees has been enhanced from 10 lakh rupees to 20 lakh rupees. The ceiling has always been linked to the Central Pay Commission recommendations. Considering the inflation and wage increase, Even in case of employees engaged in private and public sector, the entitlement of gratuity is also required to be revised for employees who are covered under the Act. This is what the bill seeks to achieve. The Payment of Gratuity Amendment Bill 2017 was introduced in the Lok Sabha by Minister for Labour and Employment Santosh Kumar Gangwar on December 18, 2017. The Payment of Gratuity Amendment Bill 2017 raises the maximum gratuity limit for non-government employees to Rs 20 lakh. If the bill is passed, it would bring the maximum tax exempted amount on par with that for government employees. Nishtha Malhotra with cameraman D.K. Pandey for Rajya Sabha Television.
Gratuity is an enhanced support which is provided by establishments to the employee. Let's try and understand how it's calculated. Mr. Sharma, how does the calculation begin? Because there are two figures. One is 30 days. So, if a month is of 30 days and 15 days salary is what you have to calculate, then there is a new adjustment that has been brought in where now the month is being treated of 26 days. What is, how does the calculation actually happen?
See, if you see the language of the section, it says for each completed year of the service, 15 days wage. And there is a explanation to this section. It says that is while calculating 1 day wage. So, that is if it is monthly rated wage employee, then 1 month wage is to be divided by 26.
The reason is because there are 4 Sundays.
There are 4 Sundays. Reason is that is they are working for 26 days in a month. So, this is provided in this law. Let me make it very clear, it is in the law. But if it is CCS pension rules, which that is government employees, central government employees who are not covered under this law, their gratuity is calculated not by dividing 26, they are calculated, that is monthly wage divided by 30, then multiplied by 15.
Okay.
So, only under this act, the amount of gratuity which is calculated is higher than what the purely government employees they get.
Oh, so, so how does that?
I have one question.
No, I'll just ask from you, sir. So, does the calculation based on 26 days, is that a better way of calculating? Does that yield a better gratuity, or is the 30-day calculation going to yield a better gratuity? That's my question.
Obviously 26 days is a better calculation. Reason being that 26 days is a denominator. So, lesser the number we divide, higher the amount we will get.
So, the 26-day calculation will yield higher gratuity and 30-day number will yield lower gratuity.
Exactly.
So, does that help? This entire calculation explanation, is that a favorable thing or not?
Yes, this is favorable thing. 26 days calculation. But one thing further, I just want to mention, Mr. Sharma is from the government. Rather, there are establishments where these Saturdays are also holidays, where the people are not working. So, this is further I am talking about, that the Saturday, Sundays, those count to 8 days.
So, you want more gratuity?
Further, exactly.
Mr. Sharma, where did the 26-day concept come from? Where did it evolve?
See, we brought this in the, we amended the law sometimes in 87. That was some judicial pronouncements were also there.
You mean Supreme Court pronouncement?
Supreme Court pronouncement that while calculating the gratuity, the monthly wage is to be divided by 26 instead of 30. Then we inserted the explanation in the act itself. So, it is now part of the law. So, it is explanation is there to that subsection, that how we calculate the gratuity. So, monthly wage is to be divided by 26 to
But another point is, if that is the logic, if 4 days is a holiday, then now there are many establishments, organizations which give 2 days holiday in a week, which is right. So that means, isn't it proper for the government to actually revise it and bring it down to?
Law doesn't stop people to pay more wages. But the present law of the land, working conditions law says that weekly off. So Saturday off, 5 days off is not in the law. It is practiced in some establishment. Some establishments are working for 5 days, some establishments are working for 6 days. But there cannot be any establishment working for 7 days. So law provides weekly off. This is why we have adjusted it in the explanation. But we cannot put it that is 20 days, because it is not the law of the land. That is 5 days week is not the law of the land. This
another point is the amount has been hiked from 10,000. I mean, obviously the 7th Pay Commission had referred to it, and for the government servants it has already gone up to 20 lakhs. Yeah. But for the other sectors, the outside people, it continues to be 10 lakh, and that is being sought to be revised upwards. Although the proposed amendment doesn't mention the hike that is going to be provided, but inference is there that 20 lakhs is the possible raise of gratuity ceiling cap. Do you think that's good enough, that needed, or not good enough?
No, basically the gratuity under the Act, that is applicable to the sectors, the factories, oil fields, mines, ports, plantation, and the
I'm on the point of the 20 lakh ceiling.
Exactly, I am coming to that. Basically, the gratuity under the Act is applicable on the basis of the central government gratuity. Whenever there is a hike in the pay commission of the gratuity, then they take the lead, and according to that, under the Act, the gratuity is increased. So, in the previous occasions, gratuity earlier was 1 lakh, then it was 3.5 lakh, then 10 lakhs. Whenever there was an increase in the pay commission, then we take up the matter for the hike in the under the Act. Since gratuity has been hiked from 10 to 20 lakh. Now, one good thing that ministry, it is in their mind. Basically, what will be the exactly outcome of that will be later we come to know only when this bill will be passed. Because every time, whenever there was a increase by the central government under the pay commission, so to revise the Act gratuity, there need to be the amendment in the Act. This is a long process. That why millions of the people are sufferers just because of that. You are talking about the limit.
Yeah,
I am coming to that. I am also coming to that.
But now the parliament is out of now the government can unilaterally suo moto on its own revise it.
Exactly.
So that has been empowered.
But exactly it is going to be 20 lakhs.
Which is a positive development.
Positive fact, and this time likely very soon it is to be, and moreover the government will also announce the 20 lakhs gratuity.
It's time for us to head into a break. When we return, we will tell you about the gratuity original law of 1972, which provided for the actual gratuity. Welcome back. The law of 1972 provides gratuity for employees of all sectors. On completion of 5 years of continuous service, the employee becomes eligible for gratuity, which is 5 times of half-month salary of the employee. Over the years, this law has seen several upgradations.
The Gratuity Act is applicable to factories, mines, oil fields, plantations, ports, railways, motor transport undertakings, companies, and to shops and other establishments employing 10 or more workmen. In the case of seasonable establishment, gratuity is payable at the rate of 7 days' wage for each season.
Title for gratuity to be calculated on the basis of 15 days' wage per year of service rendered for his total service period. And here, the 15 days wage will be calculated on the basis of 26 days a month. assuming that there are 4 Sundays, weekly off days. So, this enhance the amount of calculation. It will be divided by 26 monthly wage instead of 30, and that gives them a little more money. So, this is the gratuity calculation, and in the service period includes all authorized leave.
According to the existing law, gratuity is paid to the employee on his retirement if he has tendered his resignation after serving the organization for more than 5 years. On his death, even if the employee has not covered the mandatory 5-year period, and if he becomes disabled due to accident or disease, even when the working period of 5 years is not completed. Gratuity received during the period of service is fully taxable, and gratuity received by employees in other event is exempted from tax. The law applies to establishments where 10 or more employees work on any single day in the preceding 12 months of the year. The law also states that once an establishment is covered under ambit, then it will always be covered even if the number of employees falls below 10. In case the organization is not covered under the law, it can make a one-time payment to its employees.
Gratuity calculation is same for men and women both, all employees. The only difference is that what is required is a certain number of years of work which you must have filled in before you can be deemed to be eligible to get a gratuity, which is normally 5 years. But how to calculate the 5 years? Whether it should be every day of that 5 years or a limit or a certain number of years satisfied. So, under section 2A, what is defined is the continuous service.
When gratuity is received from 2 or more employers in the same year, the exemption limit for tax will remain the same. When gratuity is received from a former employer and another employer thereafter, the limit for exemption will be reduced by the exemption limit taken earlier. In the bill, no break by the employer from the date of joining to be eligible for the sum. Any leaves availed is not counted as a break. Nishtha Malhotra with cameraman DK Pandey for Rajya Sabha Television.
An employee becomes eligible for gratuity on completion of 5 continuous years of service. Let's try and understand what are the establishments which are included in this. So, how do we know what establishment entity is covered under gratuity and what is not? There is no clarity, and there is a lot of confusion on this.
I think you have already clarified that is establishment which are covered under the Act. Only the one thing I want to clarify is shops and other establishments which are covered under the State Shops and Other Establishment Act. We do not have any central law governing the shops and other establishments. So, states are having their laws which governs the working conditions laws of the shops and other establishment. So, any establishment which is not a shop or establishment under that particular state's law governing shops and other establishment act is also not covered under the Payment of Gratuity Act.
But sir, originally even for seasonal workers, when there are clauses in the original bill as to who all can be paid, and there is also a provision for one-time payment even if it is not covered. So, how does that work? How does the implementation of that happen?
See, seasonal work is again done in a particular establishment. So, we have to see whether that very establishment other than factory, mines, plantation, oil fields, ports, then whether that establishment is an establishment as per the law governing shops and establishment of that very state. So, that also is there may be, chances are less, but there may be some establishments which are not covered under the Shops and Other Establishment Act of that state, and also not a factory, mines, plantation, oil field, railways companies, then to that establishment this law is not applicable.
So, gratuity is something which should be made available to all employees, whether he is specifically covered under this establishment act or that establishment. As long as he is an employee, he is rendering 5 years of continuous service, it should be made available to him, irrespective of whether the states have a different law or not. Is that the way to go forward? And is there some ambiguity as to the people who are not, or the possibility that a section may not be included under the Gratuity Act?
No, basically see that since there is a wide definition that every factory, land, etc., are covered, but there is private and the public sector undertakings are also covered under the same act as on date, like State Bank of India. This is covered under the act, and the rest of the other banks are getting the service gratuity. That is a retirement gratuity, service gratuity. But since the definition says an establishment where the 10 and more people are working, those need to be covered under the act. So this is the wide definition, but still there is an ambiguity, what you said. And still we are not clear to why, since basic thing is 10 and more people are working, this is a retiarial benefit and continuous clause is there. 5 years continuous you are working there, or you after 5 years service you have been retired or resignation, then there is a clause of death also. So all those establishment has to be covered under this Gratuity Act because it is a retiarial benefit to the all. If there is an ambiguity, that need to be clear.
Yeah. Is there a possibility that any establishment or entity in this country employing more than 10% over the last 12 years or even seasonal workers may use some or the other clause to not pay gratuity? Is that the possibility?
Not at all, no possibility they may use some clause. Only I have made it very clear, if that establishment is not an establishment given in the act and also not covered under the State Shops and Other Establishment Act, to that possibilities are very remote. As I said, that is, there may be very less, there may be only few establishments to whom the state laws are not applicable and also not covered under the establishment which you have mentioned, that is even the he has mentioned. So that is in the law it is there, but there is nothing like that, that is the employer can use any other provision, something to avoid it. If the establishment is covered under the Gratuity Act, we have given the detailed provision, the coverage also, if it is establishment is covered under that provision, so no question, employer has to pay the gratuity if the employee is eligible to get the gratuity after completing of the 5 years of service, or in case of death, the dependent, it is not dependent, that the heirs are eligible to get the, nominees are eligible to get the gratuity.
Even on disability?
On disability, employee is to get the gratuity, it is total permanent disability. In that case, 5 years completion of the continuous service is not applicable.
So, if there is ambiguity as to who is covered, who is not covered, then how does the employee who has worked for 5 years continuously proceed, and where does he approach, whom does he speak to, how does he get his gratuity? That's my question.
Exactly. Basically, see, there are labor acts. Ministry of Labor, labor departments are there in the states as well as the central labor, and through their trade unions and through others, they can approach, because this is the law of land. So they are eligible.
Mr. Sharma, you wanted to say where, how this can be
I'll tell you
effectively dealt with?
Through your channel, I want to tell you the people, that is, in this also, this law is a central law but enforced by the state government as well as by the central government. So any establishment having in functioning or branches in more than one state, central government is the appropriate government, and then also for the state sphere establishment, state government is the appropriate government. Under the law, appropriate government have notified the controlling authority. Simply any person who feels that is he has been denied the gratuity, though he is eligible, simply to make one application to the controlling authority bringing in his notice the details, that is only two things he is to satisfy, that act is applicable to that establishment, means establishment is employing 10 or more persons. He has rendered 5 years of the service. So, in case of non-payment of gratuity or in case of the short payment, not full amount, then simply he has to apply to the controlling authority, and controlling authority will adjudicate the case, that is, and give the direction to the employer to pay the gratuity.
Right. Moving on, my colleague Nishtha Malhotra spoke to Mr. Santosh Kumar Gangwar, Minister of State for Labour and Employment, independent charge, to get his point of view.
Sir, what is the change that the gratuity amendment bill proposes?
वास्तव में ये एक बहुत आवश्यकता के हिसाब से 2 संशोधन किए जा रहे हैं। तय किया गया है मंत्रिपरिषद ने कि महिलाओं के लिए जो अब तक प्रसूति अवकाश 12 सप्ताह का था, उसको बढ़ा करके 26 सप्ताह का किया जाए। ये महिलाओं के लिए काफ़ी सुविधाजनक रहेगा और उनके हित को ध्यान में रखकर किया जाएगा। और दूसरा प्रस्ताव यह है कि निरंतर वेतन आयोग की में जो बढ़ोतरी हो रही है, तो अभी 7वें वेतन आयोग के हिसाब से सरकारी कर्मचारियों के लिए सीमा बढ़ा दी गई है, पर वो सीमा अभी बाकी अन्य संस्थानों में नहीं बढ़ी है। तो ये तय हुआ है कि उसी के अनुरूप इसको बढ़ाया जाए। तो संशोधन ये है कि अब तक जो 10 लाख की थी, इसको बढ़ा करके 20 लाख किया जाए। पर हम लोगों ने इसमें संशोधन ये किया है कि अंतिम फाइनल फिगर 20 लाख नहीं नोट करिए, बढ़ाएगा 20 लाख ही। पर यह है कि जब कभी भी वेतन आयोग आए और हर बार हम इसमें संशोधन करें तो शायद उचित नहीं रहेगा। इसके बाद जब भी आवश्यकता होगी, बिना लोकसभा में लाए इस संशोधन को करने का काम किया जाएगा। केवल इन 2 संशोधनों के लिए हम लोकसभा में इस बिल को ला रहे हैं। मुझे लगता है कि ये, क्योंकि मेरी जानकारी में ऐसा है कि विपक्ष के लोग भी हमको कह रहे हैं आप तुरंत इसको लेकर आइए, क्योंकि इससे कर्मचारियों का नुकसान हो रहा है।
Sir, the central government seeks to empower itself to routinely revise the maximum limit of gratuity that can be given. How will this help?
इस समय जितने भी सरकारी कर्मचारी हैं, 7वें वेतन आयोग के बाद ये राशि 10 लाख से बढ़ाकर 20 लाख कर दी गई है, पर बाकी अन्य क्षेत्रों में ऐसा नहीं हुआ है। तो इसको ध्यान में रखते हुए हम लोगों ने तय करा है कि बार बार लोकसभा न आना पड़े। हमने अंतिम फिगर तय नहीं की है। ये बात सही है कि 20 लाख के अनुरूप ही बढ़ाया जाएगा, पर जब ज़रूरत होगी तो बिना लोक सदन में आए, बिना लोकसभा पारित करे, जब आवश्यकता होगी, वेतन आयोग की जब संस्तुतियाँ लागू होंगी तो उसके हिसाब से बढ़ा दिया जाएगा।
Thank you, Mr. Sharma and Mr. Gupta. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.